Hello, everyone, and welcome to this East Coast Environmental Law webinar on assessing the impacts of renewable energy infrastructure in Newfoundland and Labrador. My name is Tina Northrup, and I'm a staff lawyer with East Coast Environmental Law. As we begin, I'd like to take a few moments to share a little bit about East Coast Environmental Law and to acknowledge the territories where we work. East Coast Environmental Law is a regional charity that provides public interest environmental law services throughout Atlantic Canada. The organization envisions a future in which laws and legal systems protect ecological health and promote environmental and climate justice. To that end, we advocate for progressive environmental law and policy. We provide public legal education in various formats, including through webinars like these, and we share our legal skills with others who are working to prevent or redress environmental harms. Our office is based in Halifax, or Kjipuktuk, which is within the unceded and unsurrendered traditional territory of the Mi'kmaq. And of course, that territory extends well beyond Nova Scotia and extends also into the territories of the province of Newfoundland and Labrador. As a regional charity that provides public interest environmental law services throughout Atlantic Canada, it's important for us to acknowledge that we also work in the unceded and unsurrendered territories of Inuit, Innu, Pescoda-Mukati, Wolastoqey, and historically the Beothuk. East Coast Environmental Law strives to uphold the treaties that apply across these lands, to work in right relationships, and to advance reconciliation through Indigenous rights recognition and through support for Indigenous law revitalization. The agenda for this webinar is as follows. After an introduction to the webinar topic and some context that provides a foundation for the discussion, we will focus on key federal and provincial environmental assessment processes that apply to renewable energy infrastructure in Newfoundland and Labrador. In particular, we'll look at federal impact assessments, regional assessments under the Impact Assessment Act, and provincial environmental assessments, and we'll explore the ways in which these processes sometimes intersect. We will do a little bit of thinking about past and future approaches to assessing renewable energy infrastructure in Newfoundland and Labrador. And then the final 25 minutes or half an hour will be for questions and discussion, and that portion of the webinar will not be recorded. To begin, as we seek to address the topic of assessing the impacts of renewable energy infrastructure in Newfoundland and Labrador, it's important to begin by recognizing the severity of the climate crisis that the world is facing and the devastating impacts that have already begun to be felt in Newfoundland and Labrador and throughout Atlantic Canada, elsewhere in Canada as a nation, and indeed around the world. It's clear that the climate crisis demands a global transition away from fossil fuel energy sources. And across Canada, governments at the federal, provincial, territorial levels, and Indigenous governments are investing in renewable energy infrastructure that can help to power the transition, and are also investing in varying ways in energy efficiency and demand-side management initiatives that can help us to reduce our needs for more power. While many communities across Canada clearly support these necessary efforts to decarbonize, it is also true that large renewable energy infrastructure projects carry environmental risks, and some carry clear environmental consequences that understandably cause community concern. And the reality is that we're living in a moment where our society today is faced with complex and truly difficult decisions about the steps we can and should and will take to decarbonize. All of the options that are available to us at this moment have impacts. Some of them have impacts that we would rather avoid, but that may nevertheless be necessary. And this makes informed and sustainability-minded decision-making a crucial necessity for our society as we seek to develop clean and renewable sources of energy, while also protecting the environment, protecting human health, and protecting community well-being. Environmental impact assessments, which are processes that go by various names and have different structures throughout Canada, are among the best tools we have to support informed, sustainability-minded decision-making by government. Some would say that they are the best tools that we have, and certainly when they are used well and used to their best, uh, they are they are invaluable in decision making. Environmental impact assessments are planning tools that enable us to predict anticipated impacts of proposed projects, and then, having predicted those impacts, to be in a position to take measures to avoid or minimize or compensate for the predicted adverse impacts. And by adverse impacts, I mean impacts that are harmful or detrimental or negative, to use synonyms that you will sometimes hear. So, at their best, environmental impact assessments are processes that are inclusive and participatory. And by that, I mean they're processes that provide opportunities for members of the public and for Indigenous peoples to contribute by raising questions, by voicing concerns, by helping to identify information gaps, by supplying local knowledge or traditional Indigenous knowledge, and in some cases, potentially even by contributing creative thinking that can help to improve project design. Those are processes at their best, being inclusive and participatory. And when environmental assessment processes are at their best, they help government decision makers evaluate whether proposed projects will serve the public interest in the long term. In Newfoundland and Labrador, mega onshore wind projects, renewed plans for the Gull Island hydroelectric generation facility, and preparations to welcome a new offshore wind industry have all inspired questions and concerns about the assessment processes that inform government decision-making in this sphere. Often, in our experience as an environmental law charity that provides community support throughout Atlantic Canada, we find that when members of the public want to get involved in environmental impact assessments, they find the processes confusing and impersonal, and they feel that there are limited opportunities to contribute meaningfully, and in doing so, feel confident that ultimately their voices have been heard and their concerns have been taken into account and have shaped decision making. With that in mind, the purpose of this webinar is to familiarize members of the public with the key assessment processes that apply and will apply to renewable energy infrastructure in Newfoundland and Labrador, particularly by highlighting opportunities for public participation and by exploring how these processes can support sustainability-minded decision-making by government when they're used at their best. So I've already used a few words and phrases that might be unfamiliar to some. And so for a little bit of a gloss before we get further in, the term that I've been using, environmental impact assessment, is a term that I'm using as an umbrella term, which is referring to a variety of impact assessment processes or environmental impact assessment processes, depending on where you're coming from and what phrasing is used in what jurisdiction. So in this case, I'm using them to refer to federal impact assessments and provincial environmental assessments by the government of Newfoundland and Labrador. In some circumstances, the umbrella term could also be used to encapsulate regional assessments and strategic environmental assessments, which are other forms of assessment processes that we will explore to some extent tonight. The phrase public participation in this context refers to participation by the general public in environmental impact assessments. So importantly, it's not to be confused with Indigenous engagement or formal Crown Indigenous consultation. And that's because Indigenous peoples, when they choose to engage in environmental impact assessment processes, have constitutional rights that are protected, protected Aboriginal and treaty rights, and potentially other Indigenous rights protected that are different from the rights and interests held by the general public. So this webinar is focused on public participation opportunities in environmental impact assessment processes, and by that we mean the general public. And Indigenous engagement and participation in consultation would be separate, although they can sometimes interconnect and interweave. When I speak about sustainability-minded decision-making, what I mean there is decision-making that aims specifically to advance sustainability or sustainable development. So this is decision-making that doesn't simply say, this proposed project is anticipated to cause harm. Are we prepared to live with that harm? Is that harm okay? How much harm are we willing to accept? Instead of taking that approach, sustainability-minded decision-making asks not how much harm I'm willing to live with, but will this project make a net contribution to sustainability? Will it make a net positive difference, even if it will include some harms within it? Will those harms ultimately contribute to something that makes a net positive contribution? So that's sustainability-minded decision-making in the way that I'm using it tonight. And finally, as I've noted, the word adverse in the context of environmental impact assessments typically refers to impacts that are negative or harmful or detrimental, both to the environment or to human health, and in some cases to cultural and socioeconomic concerns. So with that, let's take an initial high-level look at some of the key federal and provincial assessment processes that apply to renewable energy infrastructure in Newfoundland and Labrador. On the federal side of things, there are impact assessments under the Impact Assessment Act and regional assessments under the Impact Assessment Act, and we'll go into these in more detail in just a few minutes. On the provincial side of things are environmental assessments under Newfoundland and Labrador's Environmental Protection Act and its corresponding environmental assessment regulations. It's important to be aware that there are multiple opportunities for the Government of Canada and the Government of Newfoundland and Labrador to collaborate and come together in various assessment processes. One of those opportunities, and one that is particularly lively and unique and vibrant right now because it's in development still, is going to be the joint management of offshore renewable energy developments within the defined offshore area under what are colloquially known as the Accord Acts. And I'm going to say more about this in a few minutes, so don't worry if that sounds like just a word jumble for now. But that joint management regime is going to enable a number of assessment processes that will be carried out by a regulator that will be known as the Canada, Newfoundland and Labrador Offshore Energy Regulator, which will be empowered by both the federal government and the Government of Newfoundland and Labrador to carry out regulation, I would say on the ground, but really on the water on behalf of the provincial and federal government. So it's a really exciting and interesting regime, and something that'll be doing a lot to shape the face of renewable energy development in Newfoundland and Labrador in the years to come. Another opportunity for collaboration and joint processes is through joint impact assessments and environmental assessments. So this is what happens often when a proposed project triggers both a federal impact assessment and a provincial environmental assessment. It is typically ideal in those cases for the federal government and the provincial government to come together to create a single process that will assess the project. And finally, joint regional assessments when the federal and provincial governments agree to conduct them together. So although regional assessments under the Impact Assessment Act are assessments that are initiated by the federal Minister of Environment and Climate Change, the Impact Assessment Act is a federal statute that is really designed to look at effects of projects that are going to be within federal jurisdiction. And so for regional assessment to take a comprehensive look at an issue within a region, it is better for the federal government to be working with the provincial government so that the assessment can take into account matters that are within federal jurisdiction and matters within provincial jurisdiction as well, with the provincial government's support. And having just introduced these concepts of federal jurisdiction and provincial jurisdiction, I will say, to provide a bit of background for those who are new to this sphere, there are some kind of fundamentals that are helpful to understand when you're trying to conceptualize why it is that we have federal laws and provincial laws that establish separate environmental impact assessment processes that will apply in some cases to the exact same projects. The reason that we have this bifurcated regime is that Canada's Constitution sets out a division of powers between Parliament, or the Government of Canada, and the provinces. So under that division of powers, the Government of Canada has constitutional authority over a number of matters, including fisheries, marine areas that are beyond the territory of any province, migratory birds, lands reserved for First Nations peoples, and some other things. And so clearly those matters touch on environmental issues and have environmental implications. At the same time, the provinces have a number of powers, have constitutional authority over a number of matters that also have environmental implications. And these include local works and undertakings, most natural resource development within the province, civil property rights within a province, energy generation, transmission, and distribution within a province, and all other matters which, in the Constitution's words, are of a merely local or private nature. So here, what we see is that both the federal government and the provincial governments have powers that impact and implicate the environment. No one level of government between the two has exclusive authority to govern environmental matters. And so typically, provincial and federal jurisdiction, their spheres of authority, can either overlap or intersect in ways that make these fields kind of complex, but also potentially really fruitful when collaboration is possible. So historically, federal environmental impact assessments have existed to identify and assess the significance of anticipated adverse effects within federal jurisdiction, so adverse effects on areas that are within the Government of Canada's constitutional authority. And then by contrast, provincial environmental assessment processes have existed to identify and assess the significance of anticipated adverse effects that are within the province's constitutional authority. So that's why we have the two regimes, but as I've said, it's helpful when they can work together. Turning now to federal impact assessments and providing a relatively brief overview of these processes in the interest of the time we have. I'll start by saying a federal impact assessment can be required in one of two circumstances. The first circumstance is when a proposed project meets the description of one or more activities that are described in regulations that are called the Physical Activities Regulations. And these are regulations under Canada's Impact Assessment Act. So if a proposed project meets the description of one or more activities listed in those regulations, it will automatically trigger the impact assessment process. The second circumstance in which a federal impact assessment can be required is when the Federal Minister of Environment and Climate Change chooses to exercise a discretionary power that they hold under the Impact Assessment Act, which allows them to designate projects and require impact assessments for those projects, even if the projects are not listed in the Physical Activities Regulation. So this is a discretionary power that exists mainly to capture projects that are not contemplated in the Physical Activities Regulations, or they're not envisioned as a project that should automatically trigger an impact assessment. But for whatever reason, it comes to light that the project really should have one. Perhaps these are projects that were not, like they're novel, they're new, they were not envisioned at the time the regulations were established or were most recently amended, or perhaps they're projects that for various other reasons are really ought to be assessed federally. And that's a complex discussion. And if folks want, we can get into it more in the question discussion period later. So with those two circumstances being the circumstances that determine when the federal impact assessment can be required, it's worth noting that under the Physical Activities Regulations, as they stand now, there are a number of renewable energy project types that are listed that would automatically trigger an impact assessment. New hydroelectric generating facilities with a production capacity of 200 megawatts or more would automatically trigger an impact assessment. And so would the construction, operation, decommissioning, and abandonment of an offshore wind development project that has 10 or more turbines. Notably, the Physical Activities Regulations don't currently list onshore wind projects, and so that would typically not be a project that automatically triggers unless there was something about it that met another trigger under the Physical Activities Regulations and some of the other categories. But in terms of the list of renewable energy project types, it's not on there. Now, the federal impact assessment process begins with an initial phase that's called the planning phase. And in the planning phase, the Impact Assessment Agency of Canada works with the project proponent, which is the company that's proposed the project, and also works with members of the public and Indigenous peoples to review the proponent's initial project description. And the Impact Assessment Agency of Canada will do that with the other participants in order to get a sense of the initial project description, ask questions, share information, raise concerns. And all of this conversation and work goes towards creating what the agency will call a summary of issues. that will be given to the proponent, and the proponent will develop a detailed project description and also a response to the summary of issues to address those initial comments and concerns and questions raised. So during this phase, the agency will also draft a public participation plan and an Indigenous engagement and partnership plan, and those plans will be implemented if the agency determines that a full impact assessment is required, and we're going to proceed beyond this planning phase into the subsequent phases of a full impact assessment. But notably, not all projects that trigger impact assessments actually go through the full impact assessment process federally. Some of them end with the planning phase. And so at the end of the planning phase, having heard public comment, public questions and concern, and having reviewed the detailed project description, sometimes the agency determines at that stage that a full impact assessment is not required. And so it is possible for the impact assessment process to be abbreviated at this point. If, on the other hand, the Impact Assessment Agency of Canada decides a full impact assessment is required, then the impact assessment process proceeds through 4 additional phases. And I won't discuss these in detail here, but I'm happy to provide some more information about them in the questions and discussion period if that is wanted. Just say briefly that the impact statement phase is the phase in which the proponent will typically be doing the work of gathering existing information and potentially carrying out new studies to provide information to the agency to support the impact assessment. In the impact assessment, the agency, or in some cases a review panel, will be conducting the assessment based on the information provided and developing a recommendation to the Minister of Environment and Climate Change, the federal minister. The decision-making phase is when that final decision is made, whether or not to approve and release from the process. And the post-decision phase is a phase in which ultimately the decision statement is being released and the project is moving forward, and we're entering into a period of monitoring and compliance and enforcement. When we look for the opportunities where there are key opportunities for public participation in the impact assessment process, when we ask what those look like, the best and most meaningful opportunities, or the ones that I think seem most clear to members of the public as the best and most meaningful opportunities, are the opportunities that come with the first 3 phases of the process. So planning, impact statement, and impact assessment. So these are the phases where members of the public, as I've noted, will have in the planning phase an opportunity to comment on the initial project description that the proponent provides. So the idea there is that you have a very early description of the project, and members of the public can ask questions early on, provide information, provide local knowledge, help to identify information gaps, and that goes on to help define the detailed project description. The questions asked at this time and the work that members of the public can do can also shape the tailored impact statement guidelines that are going to shape what the proponent needs to develop in terms of information and kind of literature reviews and scientific studies and everything that's going to go into the impact statement that will be given to the agency. So there's a good opportunity for members of the public to define or help to shape what kinds of studies need to be done to address questions and concerns and information gaps. In the impact assessment phase, there is not a huge opportunity for the public to contribute while the agency or review panel is conducting its assessment, although if it's a review panel situation, there may be public hearings where members of the public can come and share, and that would be typical and expected. But a good opportunity for public comment also comes when a draft impact assessment report is ready. At that point, that would be released to the public typically, and there would be some time for members of the public to review and provide comment on that. Typically, the decision-making phase is not one where members of the public have impact or input directly. And in post-decision, there may be opportunities for ongoing public engagement. This could take the form of contributions to further studies that might need to be completed. So community impact studies, for example, where community members could be participating. It could also take the form of community liaison committees or potentially even unique monitoring arrangements that would have some public community contributions to ongoing monitoring. Now, just a few words briefly on the way that sustainability considerations are taken into account in the impact assessment process. The Impact Assessment Act defines sustainability as the ability to protect the environment, contribute to the social and economic well-being of the people of Canada, and preserve their health in a manner that benefits present and future generations. And sustainability considerations are built into the process through three key provisions of the Act, which say essentially that all federal authorities that are contributing to the administration of the Act need to exercise their powers under the Act in a manner that fosters sustainability. So they need to be essentially implementing the Act in a way that fosters sustainability. The Impact Assessment Act says that all impact assessments must take into account the extent to which the designated project contributes to sustainability. And likewise, when a final decision is made, the decision maker, whether it be the Minister of Environment and Climate Change or the federal cabinet, need to take into account or give thought to the extent to which the effects that are likely to be caused by carrying out the project. So I know that's a bit wordy, but essentially the likely effects of the project if it goes forward, the extent to which they would contribute to sustainability. So a few key pieces throughout the process where the question of will this contribute to sustainability, and if so, how, is front and center, although not determinative in the process. It's not the sole factor or even the primary factor that is shaping decision making under this process, but it's in there. And that's just some additional resources that we can send these out later. Just very briefly, regional assessments under the Impact Assessment Act, as distinct from project-specific assessments, regional assessments are higher-level processes that help governments to answer bigger picture questions. So typically we're looking at what would be the impact of multiple projects of a type that are introduced into a region, not necessarily at the same time, but over multiple years, so that we can get a sense of what that total impact would be, rather than looking at impacts on a project-by-project basis. So the regional assessment of offshore wind development in Newfoundland and Labrador that just concluded a couple of weeks ago asked this question of what would be the predicted environmental and human health and socioeconomic effects of introducing a new industry to a region, specifically an offshore wind industry to offshore Newfoundland and Labrador. So that was a high-level assessment, taking a really big picture look at what it would mean to introduce offshore wind development to offshore Newfoundland and Labrador. And it's hoped that the high-level work done by the committee in that case, which included high-level constraints analysis, marine spatial planning, some thoughts about cumulative effects assessment, although not a detailed cumulative effects assessment, that all of that will go on to then inform the way that projects are cited in the offshore and the way that project-specific assessments are done. So regional assessments can help to inform and contribute to project-specific assessments, impact assessments in that way. Turning to Newfoundland and Labrador's provincial environmental assessment process, as I've noted, provincial environmental assessments in the province are governed by the Environmental Protection Act and the Environmental Assessment Regulations. They're overseen by the Environmental Assessment Division of the Department of Environment and Climate Change, and they're under the supervision of the Provincial Minister of Environment and Climate Change. Under the provincial regime, proposed projects are called undertakings, and the environmental assessment regulations include a list of designated undertakings that automatically trigger the environmental assessment process. So this is very similar to the way the physical activities regulations work under the Federal Impact Assessment Act. In both cases, we have a list of project types that automatically trigger the process. And also in Newfoundland and Labrador, the Provincial Minister of Environment and Climate Change has residual discretionary power to require an environmental assessment of projects, even if they aren't on the list of project types in the environmental assessment regulations. So there's an ability to capture what needs to be captured, even if it isn't listed explicitly in the regulations. So provincially designated undertakings that require provincial environmental assessments, they include hydroelectric generation facilities and associated dams and reservoirs. They include gas manufacturing facilities, so green hydrogen production facilities would be captured under those triggers in the regulations. And there's a broad trigger for general projects that are engaged in electric power generation and the provision of associated structures, and that's where wind energy projects would be captured. The provincial environmental assessment process really begins kind of in earnest when a proponent submits a registration document to the Department of Environment and Climate Change. And registration documents will typically include a breadth of scientific and technical information about the proposed project, and in some cases will be the primary document that the department will use to assess the project and make a recommendation as to what the minister should decide when it comes to decision-making time. Within 7 days of registration, the document needs to be made public, and then members of the public have a 35-day window for public review and comment. So that's one of the key opportunities for public participation in the provincial process, and in some cases ends up being really the only opportunity for public participation, as we'll address more in a few moments. Once the window for public review and comment closes, then staff in the Environmental Assessment Division prepare a recommendation to the Minister of Environment and Climate Change as to what decision should be taken and what terms and conditions might potentially be imposed on the project if the project is going to be released. And what the Minister of Environment and Climate Change can decide at this point is one of three things. They can decide that the proposed project can be released from the environmental assessment process and proceed. They can decide that the project actually needs to stay in the process and go through further study through an environmental preview report. And they can also decide that the project needs to undergo even further analysis through an environmental impact statement. So the Department of Environment and Climate Change has some guidance documents on the process, and they're useful overviews and summaries of the materials. There's a really helpful table in one which we've reproduced here, which gives a good, helpful breakdown of the considerations that apply to these decisions. So the environmental preview report is going to come into play if more information is needed, but that information exists already in the world, it's readily available, and it doesn't require original new research to be undertaken to supply the information. Whereas an environmental impact statement is going to be required in situations where actually the proponent needs to carry out new original research and studies and retrieve new data in order to be able to give the minister the information that's needed to make an appropriate assessment about the project's effects. So when we're looking for key opportunities for public participation here, that original 35-day window for public review and comment on the registration document, as I've said, is the first and in some cases the only and best opportunity for members of the public to have their say. If an environmental preview report is required, then you get another 35-day window for public review and comment when that report is provided after it's been submitted to the minister. And it's in the cases where an environmental impact statement is required that the most opportunity for public participation really occurs. In those cases, you get opportunities for the public to participate in creating guidelines for the environmental impact statement. So a draft set of guidelines will be provided, and members of the public have 40 days to review and provide comment on the guidelines themselves, which will shape the project. There's an expectation that there'll be one community meeting near the proposed location of the proposed project. There's a window for public review and comment on the environmental impact statement after it's submitted to the minister. And there might be one or more public hearings after the environmental impact statement is provided to address the environmental impact statement, share the contents of it, and address public concerns further. Notably, though, that decision whether or not to require that public hearing is discretionary, meaning that the public hearings at that stage are not a mandatory requirement of the process. From a sustainability-minded decision-making perspective, the provincial process differs from the federal impact assessment process in that there aren't any requirements built into the provincial process that require sustainability considerations to be taken into account. So the provincial process does not require the Minister of Environment and Climate Change or the Cabinet to be asking whether a proposed project is going to contribute to sustainability or to think about the extent to which it might contribute to sustainability or how its effects might contribute to sustainability. Now, as I noted, wanted to kind of wrap up with just a few thoughts on past and future approaches to assessing renewable energy infrastructure in Newfoundland and Labrador. And I think these comments might lead into some fruitful discussion in the Q&A for those who are with us tonight. So a notable past approach, one that's already been taken to assessing renewable energy infrastructure in the province, was the joint federal-provincial environmental assessment of the proposed Lower Churchill hydroelectric generation project. So that assessment concluded in 2011, so it's well over a decade old now. But it was a really interesting one in that it was conducted by an independent review panel jointly appointed by the federal and provincial governments and jointly empowered by them to conduct the assessment. And the panel, when it prepared and delivered its final report to the governments, it really urged the government of Canada and the government of Newfoundland and Labrador to take a clear sustainability-minded approach and to apply sustainability criteria to the way that they kind of reviewed the report and assessed the project and ultimately made their decisions. As the panel put it, they thought that the sustainability criteria would be useful in identifying the range of effects of the project on sustainability, and they thought it would be useful in working to minimize adverse effects and maximize benefits. The sustainability criteria that the panel recommended are quite extensive, so I haven't reproduced them here. It's 3 or 4 pages worth of criteria written out, but it's worth noting that this approach and the emphasis that the panel placed on sustainability-minded decision-making at the time was really progressive for its time, and it was really pushing the envelope at that time, I would say, and it was pushing a vision of what scholars have called next-generation environmental impact assessment, and thinking really about this process of moving away from assessing projects by asking how much harm are we willing to justify, to asking instead, will this project actually make a net contribution to sustainability or a net contribution to sustainable development or a net positive contribution to society in those kinds of ways. So that's a past approach, which is still having obviously ripple effects and will continue to have effects going forward as continued conversations are happening about Gull Island in the months and years to come. And then in terms of future assessment processes and approaches, just worth saying a little bit more about what I mentioned earlier, which is this joint federal-provincial regime that has been designed for offshore Newfoundland and Labrador for offshore renewable energy governance in that space. So this came through amendments to the Canada, Newfoundland and Labrador Atlantic Accord Implementation Act and its provincial counterpart, which has essentially the same name, just with some slight variations for the province. So together, those statutes are called the Accord Acts, and historically, they are what has enabled the joint federal-provincial management of offshore petroleum resources in the offshore, and now they're going to enable the same joint federal-provincial management or very similar joint management of renewable energy resources in the offshore space. So under this new regime, the current Offshore Petroleum Board becomes the Canada, Newfoundland and Labrador Offshore Energy Regulator, and that regulator will be the primary regulator of offshore wind projects in the defined offshore area. So the regime envisions that calls for bids for submerged land licenses will be issued for specific kind of sites within the offshore area. And it is hoped that the work of the Regional Assessment Committee that just concluded a couple of weeks ago will inform the selection of sites that will be opened for these calls for bids. And then ultimately, the developers that secure these submerged land licenses will be able to propose projects for those areas. And having done so, they will trigger probably federal impact assessments unless something happens between now and then to change the federal assessment regime and its requirements for assessments for offshore wind projects. In addition to what might happen with federal impact assessments in this space, the amended Accord Acts regime is empowering the offshore energy regulator to conduct regional assessments and what are called strategic assessments. In this context, a strategic assessment is more or less an assessment of policy and decision-making and kind of governmental or regulatory approaches to regulation, to think about how regulation could be done differently or better to further the goals in the space. So the regulator will have the powers to do those kinds of assessments and will presumably also be empowered to conduct project-specific environmental assessments of offshore wind projects when they don't trigger federal impact assessments. But it's worth noting that that those powers haven't been made entirely clear as of yet, and so there are still some things to be sorted out as that regulatory regime takes shape. So those are just a few comments on past and future and some things to think about and maybe bring into discussion as we move into discussion. And with that, I'll simply conclude by saying a few things. One is that East Coast Environmental Law offers a free environmental law inquiry service that is open to members of the public throughout Atlantic Canada. And so um, over the past number of years, we've answered a number of inquiries that have come from Newfoundland and Labrador, and we are always open to getting more inquiries from individuals and community groups and organizations throughout the province. So the Environmental Law Inquiry Service is designed mainly to provide general legal information to members of the public. So we are typically not using the service to take on cases or representation of groups or persons, but we're providing information and in some cases can provide some strategic advocacy advice and some direction based on opportunities that exist in the law for public participation in processes like these. So to access an inquiry service, we simply ask that members of the public use the inquiry intake form that is on our website, and there's an environmental law inquiry service page on the website that makes that available. For more general questions about our work, you can always feel free to reach out to us at admin@eclaw.ca. And finally, I'll conclude this portion of the webinar by gratefully thanking the Law Foundation of Newfoundland and Labrador for providing grant funding that supported this work and that will support some associated public legal education materials that will come out on our website in the days to come. Thank you very much.